It's 9:35 a.m. and I'd like to call today's hearings to order. There are two hearings on the docket. One hearing that's before the body. I believe the individuals that are before the body now are represented. Let me see. So right now we have before us two cases. Case number 6231-1. Are those the individuals that are before us today?
Mr. Chair, this is Josephine Lee on behalf of the district. We are here on behalf of Flex Firm, case 6239-1.
Okay, perfect. And you're representing the executive office? Who's
Yes,
representing the respondent?
Good morning. I'm Melissa Hathaway McKeith. I'm counsel for Flex Firm Products.
Okay, Madam Clerk, are there any individuals who've signed up to provide non-evidentiary testimony and/or general public comment?
No one has signed up.
Okay, let the record reflect that a quorum is present. Let the record also reflect that I'm participating remotely from a location that is accessible to the public. And the location has been properly agendized pursuant to the Brown Act. So why don't we go ahead and kick it to you, my good friend representing the petitioner. Opening statements. Oh, no, I'm sorry. Actually, let me back up. We have several different exhibits with the proposed findings, which we'll mark as Exhibit 1.
Excuse me, Chair. I believe we would mark that as Exhibit 9.
Okay, wait a minute. Let me see. Okay, let me go to my notes. Okay, you're absolutely correct. So are we going to mark the clean as 9 and the red line as 10, or how are we going to do that?
Yes, that's correct.
Okay, so the clean iteration, the proposed findings and decisions, the clean iteration is Exhibit 9. The proposed findings and decisions, the red line is Exhibit 10. Are there any additional exhibits, Madam Clerk?
No, that's it.
Okay, thank you. Okay, so to the district, why don't we go ahead and allow you to provide opening statements?
Thank you, Mr. Chair. Good morning, Josephine Lee on behalf of the executive officer. I also have here my colleague, Ms. Sherry Hanizabare. Before you today is a request to modify and extend a stipulated order for abatement involving respondent Flex Firm Holdings, LLC. To put it simply, the proposed conditions will require Flex Firm to purchase a new afterburner and potentially new ovens or construct a permanent total enclosure that will comply with Rule 1128 and Rule 1147. The proposed conditions set forth an expedited timeline for Flex Firm to accomplish this goal, while imposing interim limits to throughput and related VOC and NOx emissions until the new equipment can be permitted, constructed, and installed. We've included a condition that requires the parties to come back in March 2025 for a status hearing. And to allow sufficient time for the facility to install the equipment, we are requesting this hearing board to grant an extension of the order for abatement through December 2025. In support of the modified, what we're calling the second modified order, the district has available witnesses from compliance and engineering, if that testimony would be helpful. We wanted to thank the chair for granting the parties' requests to continue the status modification hearings to today. The parties effectively used that time to participate in multiple meet and confers, including an in-person meeting at district headquarters, and where we were able to meet with Flex Firm's counsel, their consultant Ramble, along with district staff and district council. Through those joint efforts, the parties have agreed upon the proposed findings and decision, marked Exhibit 9 and 10, which identify a path forward and ensures a long-term plan for compliance, mitigates emissions, and allows the business to stay in lawful operation. We believe the proposal strikes that careful balance, and we request the board to grant the proposed second modified order today. Thank you.
Thank you, my good friend over at Flex Firm. The floor is yours for opening statements.
Thank you, Chair and members of the hearing board. I'm Melissa McKeith, Environmental Infrastructure Consultants, and this is the first time I've appeared before you on this particular matter, though not the first time before this hearing board. I have with me today Albert Castillo. He's the president of Flex Firm. He's been an employee there for 25 years, and he told me this morning, as he'll testify, it's the only job he's ever had. Next to him is Gary Elcock, who is a co-owner now of Flex Firm. He and his partners acquired this company in 2020, and we have him here to discuss what due diligence was done prior to acquisition, and also the commitment of the company to, in fact, purchase the items that Josephine Lee was speaking to previously. And finally, Yasmin Stutz from Ramble. And as Yasmin will testify, she is a atmospheric chemist. I love this word. She also was previously an inspector for the AQMD, has extensive experience, and has worked with Mr. Lee on agreeing to a methodology that will allow Flex Firm to adjust its products in order to ensure that it remains within the parameters of its permits and the commitment that we've made with council. I'd like to start by thanking the staff of AQMD. Although Yasmin and I have only been involved for 2.5 months now, we have spent extensive time tackling what has turned out to be a rather challenging exercise in taking an operation that was first started just after World War II with equipment that we had understand to be exempt, and to sample and do the source testing and obtain the information as of today that would allow us to make decisions about what is possibly available in terms of equipment that would allow this company to continue making its military specification products and stay in compliance. And so with the hearing board's indulgence, I was going to have Mr. Castillo first speak to the steps that have been taken to comply with the last stipulated order. I think most importantly, you will hear that we have had no notices of violations in the last 30 days for odors. Odors was a factor in the last hearing. That's based in part on a number of changes that Mr. Castillo has made at Ramble's recommendations. And I will then have Mr. Elcock testify to the commitment of the company to, in fact, follow the terms of the second modified stipulated order. And then if interested, Yasmina Stutz is here to speak to the work that Ramble has done and will be doing in the future, and her work with Mr. Lee on developing a very extensive methodology, which we may or may not introduce into evidence, but there was extensive work done to go back over the records over the past year to calculate emissions on different pieces of equipment, to sample the actual different mixtures and reformulations that are needed to actually do this work, and to put together a blueprint that will allow the company to proceed and continue to make its product. And in closing, I want to say that I've represented a lot of small businesses over the years. And one of the real challenges small business has is that, unlike Northrop or other large corporations, they don't have a full-time person to deal with compliance. Mr. Castillo tells me he spends 25 to 30% of his day now on just doing the work necessary to get the company into compliance. The other real challenge for Flex Firm is it's what we call a Berry certified contractor. That means that they are one of the few contractors that make coatings for the military, and the mill specs require materials be made in a certain way, and what goes into the mix actually impacts the final product. And so it's this alchemy, this balancing that has to go on, that is very complicated. And finally, I just want to say, it may sound easy to go take tests or source tests. There were 57 labs that Ramble contacted. Only 2 could run the tests that AQMD wanted run. Likewise, we conducted source tests. Very few source test companies. The one we utilized didn't actually do the tests the way the AQMD and FlexFirm had agreed. Some of these things are outside of the control of particularly small companies. And my point in letting you know these things is it's taken a lot to get to where we are, a lot of commitment on the part of the company, and it's a lot of work. It's nobody's fault. It's just the nature of an older company with older equipment evolving and getting to the place where they can operate today. So with that, I don't know if you swear the witnesses or.
Well, yes, I just wanted to make sure that you that you concluded your opening statement. And so what we'll do is we'll go ahead and swear in all the witnesses. If you would like to stand, please. I see close to 6 individuals. Please raise your right hand. Do you solemnly state under penalty of perjury that the evidence that you shall give in this matter should be the truth, the whole truth, and nothing but the truth? All right, the record is clear that you all have been administered the oath of office. All right, Counselor for the district, would you go ahead and call your first witness?
Yes, thank you, Chair. I do think that the parties have discussed, and it makes sense for streamlining purposes for
Absolutely.
FlexFirm to witness first
Okay.
to discuss the operational improvements made recently.
I have no objection to streamlining and being more efficient and moving the meeting expeditiously. We'll go over to our friends over at FlexFirm. The floor is yours.
Thank you very much. So good morning, Mr. Castillo.
Morning.
So can you just begin by telling us your title for the company today?
Yeah, I'm the president of FlexFirm Products.
And how many employees does FlexFirm have?
Currently, we employ 10 people.
And has it the 10 in average been the number of employees at your company over the time period that you've worked there?
It averages about, I would say, 12. We tend to have anywhere between 10 and 15.
And is it correct that you've worked there for 25 years?
24.
Almost time for a silver anniversary watch. During the time period that you've worked there, have the operations of FlexFirm stayed relatively the same?
Yes, very minor changes, and most of the changes were either due to suppliers either not supplying the brands that we were buying, so we would have to find different brands, even though it's the same chemistry, same polymers, nothing changes. The only thing that would change is the brand name. So, but in essence, everything has remained pretty much the same throughout my tenure there.
And I'll talk to you about the SDSs, the safety data sheets that you received, because one of my understanding in speaking with you is one of the challenges is that they don't always reflect all of the information a manufacturer needs in order to make decisions about the VOC content. But before we go there, is it your understanding that FlexFirm has been in operation since approximately 1946?
Yes.
And for that time period, was it, to your understanding, owned by a single family?
Yes.
And did that family, was that the Barry Eichhorn family?
Yes.
And he was the person who was in charge of the business and operations?
Yes. His father started the business and then Barry joined after he graduated college. But in essence, it's always been a family business.
And did he retire in approximately 2018?
Yes.
And at that time, did he anticipate his children would take over the business?
Yes. Initially, he was bringing in his kids along, his daughter, his son, and but unfortunately, I guess they were just not interested.
And were you at all involved in helping to identify a new purchaser of the company?
No.
Okay, then we'll let Mr. Elcott speak to those particular issues. From 2018 to today, did anything material change in the operations, whether the equipment changed or the particular product that you were making?
Oh, that's for
No, that's for Albert.
No, no major changes at all.
Okay, and about how many products do you make on an annual, how many different products?
It's could be hundreds. Even though most of the chemistry is somewhat similar, they all have their own weight restrictions, their own width, their own shades. So in essence, it can be hundreds of products.
And do you determine the composition of those products based on what the military specification or other customer specifications are?
Yes, the
Okay.
military specs, they have callouts for everything that goes into our fabrics.
And does it change monthly based on is it the same amount every month that you make, or does it vary over the year?
No, it varies. It's all, we make stuff to order, and it depends on the project that the government is working on right now. So we can see months where we do a lot of one product, and then the following month it will be completely different.
Does it also sometimes depend on the federal budget being adopted and whether or not different divisions of the military get funded for their contracts?
Yes.
So is it difficult for FlexFirm to anticipate on an annual basis exactly how much product it's going to be generating?
Yes.
Okay, so does that make it challenging for you as a person who's in charge of operations to predict what's going to happen in the future?
Very.
Okay. Now, you mentioned that FlexFirms is the business is flexible and dependent on budgets and the like. But my understanding, based on our discussions, is that the equipment that FlexFirm has had involves two ovens and an afterburner, and that's the same equipment that's been there since you were first employed.
Yes, correct.
Okay, and to your knowledge, before this latest experience, for want of a better word, with AQMD, do you recall there being notices of violations in the past, or the kinds of challenges that we've found today?
No knowledge before 2018. I have no knowledge. I wasn't privy to that information, but we would rarely see AQMD staff at the facility.
Okay. And when you started having concerns raised by the district about odors, did you hire a consultant to assist you in determining compliance?
Yes, we hired a furnace consultant, and then we also hired various other companies that would come out here and take a look at the outside of the unit to make sure that it was in good condition.
Okay, and that's because you needed to rely on experts to give you advice on what would be needed.
Correct.
Okay. And just for the record, the last time you were at this hearing, you weren't represented by counsel, correct?
No.
Okay. And the management of the company wisely decided to hire me after that. And
Yes.
And I appreciate that. I think it's a very complicated process. So the first thing we did is we took a look at your manufacturer SDSs to determine what their VOC content was. Did many of those documents not have any information about VOCs at all?
Yeah, most of them don't have the information. The only ones that would have it would be the solvent, so we knew of those, but all the other stuff, no.
Okay, and did you ultimately send those samples to a laboratory to have each of the mixtures analyzed?
Yes, we did.
And did the ultimate analysis differ from what your understanding had been of the levels of VOCs in these materials?
Surprisingly, yes.
Okay. And do you understand that under this new second modified order, if the board approves it, that you will then be sampling those mixtures again?
Yes.
And do you use approximately 10 different mixtures?
Yes.
And will you reformulate those mixtures based upon the VOC content when the laboratory data is received?
Yes.
Okay. Another requirement of the modified order that was issued in July was that you undertake a source test. Did you hire a company to do that source test?
Yes, we did.
Okay. And did that source test conclude that your capture was 95% of?
From the test results, yes.
Yes, but the district rejected those test results.
Correct.
And the district rejected them, to your understanding, because they didn't comply with, Alliance didn't comply with the protocol.
Correct, yes.
Right. And did you have any control over what protocol Alliance utilized?
No, they wrote the protocol that was accepted by AQMD staff, and we just figured they would follow that protocol.
Okay, so in the end, were you disappointed that Alliance didn't follow that protocol?
Extremely, yes.
Okay, and did Alliance then retake that source test?
Yes, it did.
Okay, so to your knowledge, we're in compliance with that requirement of the order?
Yes.
Yes, okay. And last time you were here, there was a lot of issues about odors. Since August, there have been no notices of violations that you've received. Is that correct?
Correct.
Okay. And can you, I'm just gonna walk you through and for the purposes of the hearing board, these are listed in the actual second modified order. There's a number of steps that it indicates that you took in order to address some of the concerns of AQMD. And the first one was you sealed up openings, improving the inward velocity of the oven, matched the limit controlled and the temperature controllers to reflect a more uniform temperature indication. Is that correct?
Yes.
Tell us what that means in lay words.
So we sealed up any openings that were not necessary, that weren't necessary to the operation. We also sealed up the openings in the front end and the back end of the oven to maximize the capture efficiency. And doing that, the airflows and the temperature controller both kind of, I guess, working together. They were able to keep the temperature a lot more steady than in previous occasions.
And is it difficult to keep the temperature stable? Is it a,
Yeah, depending on what we're running and obviously temperature in the day, right? Now, when days are colder, it takes more gas to heat up the afterburner, and sometimes we may see some oscillations here and there, but thankfully we've been able to work through that too.
okay. You provided afterburner gas usage reports from January 2023 to the present to the South Coast in compliance with the order?
Yes.
Okay. You performed sampling and VOC analysis of all coating materials and provided the results to South Coast?
Yes, we did.
Okay. We recalibrated the modulating damper motor and firing rate gas valve to smooth out the operations.
Yes.
You want to explain that in a little bit more detail?
Yeah, so we noticed that the modulating motor was either not behaving properly, and at first we thought it was the temperature controller, but there was obviously something wrong with the motor, so we had that motor, worked on. Our consultant came, took a look at it, and then for the temperature controller, so that they both can be working together as efficiently as possible, we had to call the temperature controller suppliers. Spent several hours with them, over the phone, and then they submitted a video that we had to watch. And then understanding how the temperature controller functions, we were able to change some of the PIDs and some of the settings, and that really made sure that the oscillations were minimal.
And it says here you purchased a new exhaust variable frequency drive motor. How did that help?
It helped because it improved the airflow. We weren't sure what was going on with the airflow, but the oscillations can be due to either increased airflow going into the system or decreased airflow. We didn't know the motor was good or the blower was bad. So we opted to buy the VFD motor and, set that to the correct settings. And that also helped with the temperature, being steady. And then to my knowledge and my understanding is that significantly improved the destruction efficiency now that we have a steady temperature.
And you installed a new viewing port to observe characterizations of the flame. Tell me, do you do that, or does another employee monitor the flame?
Well, I take a look, and then if based on our furnace consultant, he more or less explained how the flame should behave inside the unit. And if I saw something that that I thought was not right or it looked a little off from what he explained, then I would call him and he would come over and take a look for himself, and then he can tell us whether something was going wrong or not.
And the final thing is that you've adjusted gas usage to stay under the 230,550 SCF per month.
Yes.
And does that have the amount of gas you use, that has a direct impact on the number of product you can produce and sell? Is that correct?
Yes.
Okay. And so that is a driving force in the company making decisions about how we might be able to maintain our actual production by purchasing new equipment that will help to address some of these issues.
Yes.
And have you been involved in speaking to vendors and trying to identify the correct afterburner and PTE, permanent enclosure?
Yeah, we've spoken to several.
Mm-hmm. And do you find that it's hard to get a company that will guarantee the actual performance of these expensive pieces of equipment?
They they all guarantee it on the initial call, but once they take a look at our processes, that's when they have questions and they have to go back and do calculations and, and their tone changes a little bit. So it is kind of a little bit difficult to make sure that they guarantee it off right.
I'm going to have Yasmin Stutz speak to the workbook that is created where you can actually keep records on a daily basis. Can you first tell us just what equipment do you have that automatically reads the ovens and the concentrations or the emissions, so that a lot of the information that goes to AQMD is actually not something you have to manually measure, but is actually recorded by equipment?
Well, the equipment itself has timers, non-resettable timers, and then it has the oven number one, which is the one with the afterburner. That one has a gas meter outside where we can take the readings every morning and we put them into the workbook.
I see. And this document, this is your workbook, correct?
Yes.
So this is a hard copy of an Excel spreadsheet, and I will not go through the detail, but I take it that there's a considerable amount of your day that's spent complete information that's required to demonstrate that Flex Firm is staying within the methodology and the criteria of the workbook.
Yes,
Okay.
there is.
Okay. That's all I have for the moment. I don't know if Ms. Lee cross-examines now or.
Yeah, yes. Ma'am, there's a chair here. We have it under control. Thank you. Ms. Lee?
Oh, I'm sorry. I apologize. I almost called you Your Honor, but I apologize.
Okay. Ms. Lee, would you like to cross?
Yes, thank you, Mr. Chair. Thank you for your testimony today, Mr. Castillo. Just wanted to clarify, you had testified regarding expected reformulation, which I think pertains to proposed condition 17. So that reads that the facility will be testing all coatings that were reformulated after September 2024. Is that still the plan?
Yeah.
Okay, I wanted to clarify that. And that retesting should be conducted is expected to be conducted no later than December 13th.
Yes.
Thank you. And that's pursuant to the test method set forth in the rule 1128.
Yes.
Okay. I appreciate you outlining and setting that factual foundation for all of the operational changes that were conducted. If I had questions regarding the June 20th source test or the throughput limit, is that best directed to you or to Yasmin? Ms. Stutz?
Throughput will probably be me, but the other.
In terms of the methodology for that?
Yeah, the methodology we have.
Okay, then I'll reserve those questions for the appropriate witness. Thank you. Other questions? Oh, I think you're on mute, Chair.
Is there any redirect on the Flex Firm side?
Have you had an opportunity to review the proposed order?
Yes.
Actually, we didn't get a copy from the.
You've never received a copy of the?
Well,
proposed
we
agreement?
received it electronically from council. The proposed. Can I make the correction?
So, Counselor, did you receive a copy from the district or?
Yeah, I just wanted to
email?
show. Oh, absolutely. We worked on it collectively.
Okay,
Yes,
perfect.
I just wanted to show the witness so that he can confirm his intentions to comply with the conditions of the second modified order. That's.
Yeah.
So just so that we're on the record and you understand, have you read through the conditions that will be required of Flex Firm over the next 6 months to a year in order to implement this second modified order?
Yes.
Okay. And you intend, as the president of the company, to make all good faith effort to comply with those particular items?
Yes.
Yes. Okay. And in connection with the second source test and the sampling, the lab sampling, that was done under the direction of RAM, correct?
Yes.
Right, and I can address questions to Ms. Stutz if we have any. Is there anything else you'd like to add for the hearing board this morning?
No, thank you.
That's all.
Thank you. Members of the hearing board.
Sure, a couple of questions, Mr.
Mr.
Castillo.
Kerman.
Paragraph 10 of the proposed of the findings mentions 3 notices of violation. I take it they occurred between May 28th and August 7th. Is that
Correct, yeah.
true? Is that a yes?
Yes.
And so, what was the cause that led to those notices? And if you determine the cause, what was the cure that you effected?
It was the odors, and we just improved housekeeping techniques in the warehouse. We made sure that we're keeping anything that's that could cause odors away from, you know, from any exit, so that we can keep them closer to the machine. We did some repairs on the unit, you know, ducting. We also, I think, what we mentioned was the fixing of the oscillation that gave us a more steady temperature. In previous occasions, temperature would fluctuate. You know, so it would dip down and then go increase by 100 degrees difference. And once we got that settled and temperature was able to maintain on a constant 1440 degrees, we noticed that odor complaints and essentially NOVs were minimized.
Does the facility get complaints directly from members of the area and the community directly?
Not directly, they're always through an inspector of the AQMD.
The order, proposed findings, I should say, we talked about the follow-up source test conducted October 15th. The results are still not in yet.
That's correct.
And then paragraph 13, you've got an option that you can either buy a new afterburner and CTE or a new afterburner and oven. Will that choice in any way depend on what the results are of the source test, or do you see those being independent decisions?
They will be independent decisions.
Go ahead.
We based on the sources, I think we're still committed to upgrading our equipment, but I think that's the where we're leaning more towards.
And is your understanding that, and this probably should ask the district too, it says that your parties are working diligently to determine which option is most feasible. So is your understanding that you could decide which to do, or do you have to get the district to agree as to which choice you elect?
We would decide what we think it would be best, and we would consult with AQMD staff, and then if in agreement, then we can go ahead and move forward.
Can I, because that has a legal aspect to it, and perhaps I can answer the question like this. The district sets the standard, the goal that the company has to meet. And so if they can meet that by having a afterburner and a permanent enclosure, and after doing the testing, they meet the permitting and district requirements, that's more than $1 million less than purchasing all new ovens and afterburners. I can have Mr. Elcock speak to that too, but that's going to be the determinative factor. And because there are many moving parts, what's in the reformulations, what does the source test come out with, that's going to dictate whether or not the less expensive, which is still $500,000, it's not inexpensive by any stretch of the imagination, whether that's going to be the option, or whether or not we're going to have to replace all of that equipment in order to be able to continue to do business in the South Coast. So those are the business decisions that they're looking at. But in the end, they have to meet the rules, and that's going to govern. But in terms of whether or not we're going to work with the district and be communicating with them on the permit to operate and construct and meeting these standards, I think we've developed a good relationship with the district and intend to continue to maintain that relationship. They've been very helpful once we got it on track. Mr. Elcock would like to add something. Chair, should we let him?
Well,
Well,
Mr.
the
Pearman,
board's-
did you release the floor, Mr. Pearman, or are you still questioning?
Yeah, I'm finished. Thank you.
Yes, Counselor, go right
Mr.
ahead and allow your other person who's
Yes,
been sworn in to provide some context to that.
Mr. Chair, I do have a few questions before we go back to the attorney.
Sure, go right ahead.
Thank you. Mr. Castillo, did I hear that your title is president?
Yes, well,
Okay. Are you
president,
also a part owner? Or total owner?
no.
Okay, how many other owners are there? How many owners?
It would be Gary Alcock and AJ Jagtian, two.
Two of you, okay. So when it comes to making decisions, who makes the decisions? The two of you, or do you have a board of directors or?
We all confer, but, you know, it would,
I think that Mr. Elcock, since he is the owner of Flexform Holdings, would be better able to answer those questions.
Okay, I'll wait till he's deposed. Thank you.
Mr. Chair, I have a few questions for
Go right
Mr.
ahead,
Castillo.
Mr. Balakapalani. Go right ahead, sir.
Thank you, Mr. Castillo. In response to Mr. Pearman's question, what I heard is that, are you planning a phased approach? Are you planning to just do the afterburner and PTE test it, see how it works, if it meets the efficiency and the capture efficiency, and then decide whether you're going to replace the others? Is that what you plan to do, or?
so that would be the first approach. But we have to consult with, you know, the suppliers and to see what, if there are any impediments to that. So let's say that for some reason they say that their new equipment will not work with their ovens, well then obviously we will have to change the entire oven. But if they can guarantee the destruction efficiency, the NOx limits, and all the rules that, you know, that AQMD has, then, you know, whatever works best.
Okay, because it's condition 19 says you submit the application to replace the existing non-VOC and VOC oven and afterburner, all three, or afterburner and PTE. So you're still exploring. Is that what I'm hearing? You know, afterburner with PTE,
Yes.
and then
Well, the PT and the afterburner are together, and then the oven itself is gonna probably be subject to a little more discussion if needed. If not needed, then I guess we won't do it, but at least to meet the destruction efficiency and the NOx and all the rules of 1128, 1147, we will definitely be doing that.
okay, the tests that was done recently, the retest for the 1128, and you didn't. I mean, we don't have the results yet on the. Now, there are two components to the test, correct? Capture and destruction efficiency.
Yes, correct.
So, where did it have the adequate capture efficiency to your knowledge?
To the test, we rely on the test, and the test, you know, I think mentioned over 95%, but in conferring with AQMD staff, they said that there might be other things to look at, not just the capture efficiency on the test itself.
Okay, when you say 95%, are you talking about the destruction efficiency?
No, the
Capture.
capture efficiency. I think it was over 90% or 95 or above. But they were, we don't have the results yet, so I can't tell you exact
Okay.
percentage, but they
What
met
about the destruction efficiency?
we don't
Yeah,
know
somebody
yet.
else can answer that better. Just let me know. I'll ask the.
We don't, well, we don't know yet because we don't have the results yet, but yeah, once we get them, we'll definitely share them with AQMD staff.
Okay. The other condition 13, which was has been replaced. The previous condition was different. So now you shall emit no more than approximately 1666
Mhm.
pounds of VOC per month.
Mhm.
And they will be calculated using methods approved by their engineers from
Yes.
AQMD. Has that been already finalized, or is it still ongoing discussion
No, it's been finalized. We have the workbook, and now all I have to do is, work on the production side and make sure that we meet.
for the 1666?
Yes.
To your knowledge, do you know that's based on the assumption that you're having the required efficiency and capture at the afterburner, or is it based on, is that a sliding scale? Do you know?
Yasmin would be best to answer that.
Okay.
Yeah.
Yeah, we have the witness here who worked on putting that book together, and so she would be able to explain what the inputs were.
Now, I think Mr. Pittman asked this about the NOV. You have not received NOV since August, but what about, as to your knowledge, not all complaints result in NOV. Do you know, have inspectors come out and say they've been receiving odor complaints
Few occasions.
after,
Yeah. Yeah.
since August?
Since August, maybe twice. I don't really recall, but it's been actually very low than previous occasions.
Right, but it's still, I mean, my question is if it's still ongoing, even though it's slower.
I would say yes, only because we had.
Don't we have
one
someone from
complaint,
the
but,
district who could?
It's been significantly reduced.
The last question, I had condition 20. It says that you will provide copies of purchase orders or components and services necessary to construct and install the new equipment. So this, yeah, are you waiting for I'm just a little concerned if you don't have the permit approved, and what is the purchase order for? What component? Do you know what it'll be, or it'll be based on what, I guess both parties agree? So let's say you're going with the afterburner with the PTE, then you will go ahead and sign with the supplier of the RTO for this 128, even before getting the permit to construct.
We would issue a purchase order and then submit proof of that to AQMD staff.
Okay.
And then from there, obviously, once all the calculations and whatever the supplier needs to actually begin construction, then I'm pretty sure that's when we'll start submitting the permit applications to construct. But the suppliers, I think a lot of the suppliers do that on our behalf, or they help with that,
With
the permitting. So we would go based on when they're ready to start construction, I guess. That's when they have mentioned that they help with permitting, or at least tell us when permitting can be started so that we get the ball rolling here.
Are you aware that you cannot do any construction until the permit to
Yeah,
construct is?
That's why the suppliers will tell us, we're ready to start, submit your permits, and then we'll start construction once they're approved. So they'll let us know.
Okay, and the reason I brought it up, there have been some situations, not often at the agency, but sometimes you submit something, the district may not approve that particular control method, and you have already submitted a purchase order. Are you bound with the purchase order if the district disapproves your application?
Well, that's something that we're gonna work with Rambo and hopefully Melissa.
Well, we're hoping they have better lawyers than to let that happen.
Okay, I'm sorry.
Yeah.
Can you let?
Yeah, so we'll drop a contract that Melissa and Yasmin will help us draw the contract so that we, everything's done appropriately.
Okay, all right. No further questions. Thank you, Mr. Castillo.
All right, Ms. Verdugo Peralta, did you have another question?
Not for Mr. Castillo, for the other witness, and I will wait until he starts.
Okay, so then we'll go ahead and we'll excuse this witness and we'll bring up the next.
You can go ahead and change this. Get that.
Good morning, Mr. Elcott. Do you want to give your name and your position with the company for the record?
Gary Alcock, co-owner.
And what company owns Flex Firm Products now?
It's called Flex Firm Holdings LLC.
Okay, and are you a member of the LLC?
Yes.
And who are the other members?
AJ Jagtiani and myself.
And to your knowledge, do you comply with the corporate rules required by LLCs?
Yes.
Are you familiar with the LLC structure?
Not as much as a lawyer, but yes.
Tell us a little bit about how Flex Firm Holdings went about identifying Flex Firm Products as a potential acquisition and what was involved in acquiring the company.
I think we knew a business broker some years ago who recommended the business to us. We were looking for a local business. I lived in Los Angeles. It made a lot of sense to look at manufacturing. I have a background in manufacturing. She showed us the business. We reviewed the financials, thought it looked like an attractive investment, primarily based on the financial information. And we did the proper diligence that we would do for any transaction.
As part of that due diligence, did you come to AQMD and review permits?
We knew we had to take on permits. We were made aware of the permits and we did review them as part of the diligence. And then after the acquisition, we went to the AQMD and moved those permits.
And at the time of the acquisition, were you aware of any notices of violation against Flex Firm?
No.
Okay. And in connection with the most, I don't know how to describe this, but the events that have occurred since 2023 relative to odor complaints and dealing with the district, have you been involved in overseeing that particular part of compliance?
In terms of handling
Right.
the issue
Mhm.
overall, yeah, we've all been involved. So, yeah,
So did you hire a consultant to assist you?
yes.
Right. And did that consultant inform the company that the equipment that Flex Firm had was in compliance with AQMD rules?
He told us it was exempt.
Okay. And there's still an outstanding issue as to whether or not the afterburner is exempt, to your knowledge?
Correct.
But in order to not relitigate that particular issue, has the Flex Firm Holdings made a business decision to replace that afterburner to avoid further questioning about its effectiveness?
Yes.
Okay. And have you had an opportunity to review the proposed order?
Yes.
And is it the intention of the company to continue using an expert like Ramble in order to assist with identifying what type of equipment would allow Flex Firm to continue operating in the district?
Yes.
And as part of that, have you been evaluating different options, which include potentially replacing all of the equipment or part of the equipment?
Whatever it takes to get into compliance.
Okay. And you're aware of the fact that the identification, the permitting, and the construction of that equipment has to occur within approximately 1 year of this particular order?
Yes.
And do you intend, as part of this, to work with the district in terms of ensuring that the company is in compliance?
Definitely.
Okay. And that's all the questions I have at this moment.
Ms. Lee, would you have any questions on Cross?
No questions for this witness. Thank you.
Thank you very kindly, Ms. Lee. Ms. Verdugo Peralta, the floor is yours.
Thank you. I just wanted to verify, sir, that you are part of the decision-making process
Yes.
when it comes to the decisions for the equipment. And is it also the contractor that you hired? Are they part of the decision-making process or providing you with information to be able to make those decisions?
Do you mean Ramble or do you mean the manufacturer?
Whomever.
Oh, yeah, whoever. Everybody's going to provide us advice, but we're just going to look to the AQMD for the final say on what we should do.
I just want to make sure that the decisions that you are making are, of course, in compliance with the AQMD, but that you also understand what these decisions mean and the long-term effects of what these decisions are. versus just being a partner who just, hires people and lets them make the decision. Since you are the partner, and especially the fact that this is for the military and they have specific specifications. So I just wanted to inquire about that.
Yeah, the cost of the equipment I anticipate is going to be tremendous relative to the size of the business, but we are committed to whatever it takes to get into compliance. That being said, we also fully recognize that this business is a military contractor. We have formulas that have to be adhered to, and we have specifications that have to be adhered to. There's no change that we're going to make to our codings that affects that. Otherwise, we're not in business because we're not doing what we're supposed to be doing. That being said, we do intend to see if there's ways that we can reduce the VOC content in some of our coatings. We want to continue testing since we've only had one group that actually tested it. It was very difficult to find anybody that could test these coatings, and we want to make sure it was done right. So that's part of the process as well.
Is the military your client that, are they aware of all that you are having to do to come into compliance before you provide them the product?
I think that given we're an aerospace and defense manufacturer in Southern California, they probably are aware that, it's a high.
I'm not talking about just assuming because you're in SoCal.
Yeah, I don't think so, no.
Okay, so you have not specifically explained to them what the situation is?
No, they would not be aware of that.
And you don't.
We also don't sell direct to the military. We sell to suppliers.
Okay. I'm just concerned. I would think that you would share that information, especially with the military. And if you have any delays or I guess requirements that you have to adhere to based on the AQMD's discussions with you and what you have to do, that you would share that with them.
Well, we do follow ISO protocols. So, sometimes there's site visits. They have us fill out documents and forms, and we fill them out correctly every time. So whatever's required of us, we always do that for our customers. We'll sell to Northrop Grumman, those types of companies, and they have a pretty robust process for making sure that they know what's going on with the operation.
Yeah, as does the military.
Yeah.
Okay, thank you.
All right, thank you. So members of the hearing board, it appears as if Ms. Lee and the district is interested in streamlining this process. So are there any other specific questions? Do we need to proceed forward, or can we move to closing? What is the tenor of the board?
I do have a follow-up question for Mr.
No
Alcoff.
problem. Go right ahead, Mr. Balakapalan. The floor is yours, sir.
All right, Mr. Alcoff. So again, I was just trying to clarify the sequence. Are you planning, or based on input from the supplier, the manufacturer of the afterburner, if they recommend just doing the afterburner with the PT, do that first, test it and see if it meet all the efficiency requirements? What's the thinking before replacing the ovens, or if they're going to say no? If they come back and say, you have to do all at the same time, and that's what you do?
So it's hard to answer that question until we cross that bridge, except to say that the goal between myself and the other co-owner of the business is to purchase whatever equipment it takes to get into compliance. So we would look to the AQMD for that guidance primarily.
With all different, that's not the AQMD looks at permitting and meeting of the rules and regulation. It's your business decision whether what equipment you install. So it's the decision to install an oven will probably hinge a lot more on the manufacturer than the AQMD, I would think. So
I think. So I'm not the most technical person available here, but I think Yasmin would be best to answer that specific question.
All right. Now, when you purchased the facility in 2018, I assume you did a walkthrough.
Yes.
Did you notice at that time all the ductwork, some of the holes and so forth in the ductwork that needed repair?
The facility, the business has been around since the 50s, so I expect
my question. It looks like we heard testimony previously too. There were a lot of repairs that need to be done, ductwork?
I wouldn't say at the time that we looked at it that there was a lot of repair. We're not burner experts, so we didn't recognize that there were repairs that needed to be made at that time.
Okay, thank you.
Thank you. Thank you very kindly. So why don't we go ahead and jump over to closing?
Mr. Chair, I do think hearing Board Member Balagopalan's question, it may be helpful to have a technical witness to at least quickly go over.
Not a problem.
Great.
Ms. Lee, the floor is yours. So would you like to call the technical witness, Ms. Lee, or will it be the Flex Firm's technical?
Before that happens, Mr. Chair, I believe Madam Clerk has a question.
Go right ahead, Madam Clerk.
I just needed to get the spelling of Mr. Alcock's name.
ALCOCK.
ALCOCK.
Mhm.
Okay, thank you.
Thank you, Madam Chair, Madam Clerk. All right, so the respondent, did you want to call and she's been sworn in for the record, so why don't you go ahead, ma'am, and provide a measure of deposition so that there can then be follow-up questions.
I understand. So I'm going to just again shorten the hearing. I'm going to focus on the questions that are being raised about how the decision is made with regard to whether the afterburner and PTE will be effective, and then the timing and the process of those permits and what your role would be as the environmental consultant working with the company in getting those permits and identifying the equipment. So can you speak to the question that the gentleman had?
Ms. Could you introduce your witness and have a spell a name and title, please?
I'm sorry.
Hi, my name is Yasmin Stutz. Last name is spelled S-T. Pardon?
Ma'am, can you get closer to the microphone?
Yes, sorry. My name is Yasmin Stutz. Last name is spelled S-T-U-T-Z.
Ms. Stutz, for whom are you employed?
I work for Ramble America's Engineering Solutions.
And as in your role helping Flex Firm, are there other individuals at Ramble who have assisted on this matter?
Yes, Joe Hauer.
And do you know how long Mr. Hauer has worked on permitting and construction of equipment in the AQMD area?
It's over 35 years.
Okay. And how long have you been working on AQMD related matters?
Starting at AQMD as an inspector, I 25 years almost.
Okay. And so you're familiar with the coding business in general and Flex Firm in particular in terms of their compliance obligations?
Correct.
Okay. And have you been working with Mr. Castillo in terms of assisting the client and identifying what immediate steps can be taken to better comply, and then long-term what their options look like to reach compliance?
Yes.
And in connection with that, tell us how you will go about assisting them in identifying the type of equipment that will allow them to meet 1128 and 1147.
So there are two requirements for control equipment in 1128. The first is the capture efficiency of 90%. The second is the destruction efficiency of 95%. One of the recommendations that we have made is a permanent total enclosure, which would basically capture all fugitive emissions. So we would, recommend that be designed to the EPA method that is required, and assist as requested with that. And then as far as I think one of the questions was, how do you guarantee that it has the 95% destruction efficiency? That's going to be a manufacturer's guarantee, along with, a low NOx burner manufacturer guarantee for NOx emissions.
Okay. And have you purchased that type of equipment or assisted clients in the past with purchasing afterburners and dealing with the manufacturers to make sure that they don't buy a pig in a poke, so to speak?
Ramble has, yes.
Yeah. Okay. And what is your understanding of the conditions of this second modified order in terms of the timing of doing that particular work? Like, just walk us quickly through the steps from today to flipping the switch.
Okay, so my understanding from the order is that the facility has 90 days from today to submit permit applications and for whatever new equipment that they decide on. And then they are required to install the equipment within 6 months of permit issuance.
No further questions?
Thank you. I believe, Ms. Lee, were there any cross? Well, I'm sorry.
Yes, just,
Go right ahead.
yes, just a few. Thank you, Ms. Can you hear me okay? Okay.
Yes, absolutely. My screen is
so-
frozen. Go right ahead.
Yes, thank you. So thank you for walking us through some of those conditions. Just so we can give some more context to the board, because it is a new condition. Condition 13 requires emissions to no more than 1,666 pounds of VOC per month. Can you tell us where that limit has come from?
That is a limit to remain below the Title V threshold for VOC emissions.
So 10 tons of VOC per year, and per month, that's 1,666.
Correct.
Thank you. And you've been working with district engineering staff on what we've referred to as a workbook that will help the facility to practically stay under that limit.
Correct.
Yes. And the timeline, is it atypical for purchase orders to be made after an application is submitted, but before the permit to construct has been issued?
I don't think I have the experience to speak. to
Okay,
that.
okay, I just want to see, but that's your understanding of what the order requires.
Yes.
And Ramble would be working with the facility to ensure compliance with those conditions.
Correct.
Okay. I think that's it. Thank you. No further questions.
Yeah, members of the hearing board.
Mr. Stutz, sorry. Let's go back to condition 13. That's 1,666 pounds of VOC per month.
Mhm.
And does that based on certain efficiency of the afterburner?
Yes.
And so if the afterburner doesn't meet efficiency, is there a sliding scale then the emission should, or,
How we have set up the workbook is we have used a very conservative 74.5% destruction efficiency based on a source test that was completed last year. And because the more recent source test that showed 95% destruction efficiency, we know that it was biased high, and we can't say how high that was biased. So we've relied on the lower destruction efficiency for the emission estimate.
okay, that's good. That it clarifies that. As far as you know, I remember the 75% efficiency of the VOC, which was very low. Subsequently, they did the retest, which was not accepted. But you know, if they did both, they had results for both collection and destruction.
I believe it had capture efficiency and destruction efficiency, but the source test was never approved.
Right, but preliminary, did it comply with the 28 limit? As far as like the collection should be 90% by weight, correct?
Yeah, and I believe that they didn't have the videos to be able to determine. I don't think that was determined by the AQMD source testing group as to what the capture efficiency was.
So that 74%, was that an overall efficiency used to calculate, or is it based on destruction only?
So that 74.5% was destruction efficiency from the source test. We have also applied a 90% capture efficiency to our workbook. That is an assumption that the 90% is being captured.
And if, say, the last source test showed a much lower number, then what would be the consequence of that?
I'm sorry. What did you say?
No, the two assumptions you made are 90% collection and destruction of 75%. But if the source has showed that they don't have that high collection capture efficiency, will that scale?
We can adjust the workbook
The workbook
as
is-
soon as we know.
Okay, all right. Then let me, as far as the, what I'm hearing, and correct me if I'm wrong, is, and if what you're understanding that they are looking for a manufacturer who can guarantee they can meet the, efficiency capture and control, and also meet the 1147 limit. And with the PTE, I'm assuming that's what the plan is, right? To go with, that's the first approach, do that. And if then they don't have to replace the oven if they meet it, is that?
I mean, if they meet the requirements of the rule, they shouldn't have to replace the oven.
Okay. So even though it's a, and because it says and or after so
Mhm.
so that'll be the first step. They'll test it, and then after that they'll decide. So I'm just worried about the timeline. Then let's say after the testing they found, or the manufacturer says no, there's problems, we need to replace the oven. How long was that going to prolong the period of non-compliance?
I mean, I think the concept is that they're going to make a decision on whether or not they need to just replace the afterburner or replace the afterburner and the ovens. And all of that will take place within this short time period in which we need to apply for permits.
Oh, okay.
So all of that should be reconciled and applied for within that 90 days is my understanding of the order.
Okay, all right, that I'll clarify. Thank you. I have no further questions.
Are there any additional questions from members of the board? All right, perfect. We'll move to closing statements.
Thank you, Mr. Chair. My colleague, Sherry Hanizavare, will be presenting the district's closing.
Good morning, Chair Ali and members of the board. Before I get to my closing, there's one edit to the findings and decisions, just a very minor one. Actually, sorry, two edits. I want to pinpoint them for you. On page 2 of the findings and decisions, the second full paragraph, it states respondent Flex Firm Holdings was represented by Melissa Hathaway McKeith. She actually was not representing them at the first hearing. So if we can change the was to is to indicate that she is representing them now. And then I would like to point out page 6. So under the subheading second modified order, condition 19, so I think that's on line 20, should be its own separate paragraph. So we're sorry about the spacing on that. Okay, so I will give you my closing. Good morning once again, Chair Ali and members of the board. As you've heard today, the district is encouraged by the progress and the cooperation that we've seen over the past several months while working with Flex Firm. They've onboarded counsel and consultants, and as we've discussed, we've engaged in numerous meet and confers. Flex Firm staff and district staff were particularly encouraged by their commitment to purchase new equipment. As we discussed, either a new afterburner and PTE or alternatively afterburner and ovens. The district does acknowledge these are significant and costly steps, and we hope that Flex Firm can relatively soon, by taking these steps, demonstrate compliance with rules 1128 and 1147. I'd like to kind of focus on some of what we touched on a little bit because I think it's important to highlight. If you recall from the last hearing in May, we talked about maybe 9 public nuisance NOVs that had been issued between the 2023 hearing and the 2024 hearing. Again, we're encouraged by the fact that since the May 2024 hearing, there have only been 3 NOVs issued for public nuisance, the last of those being issued in August of 2024. So given these recent trends and bolstered by the testimony that we've heard today, the district is respectfully requesting that the hearing board grant this modification and request for an extension subject to the conditions that were stipulated to by the parties. Thank you.
Thank you very kindly. The floor is yours.
Thank you, sir. Just briefly, I want to thank staff at AQMD and the council's office. We worked many, many hours on getting to a place where FlexFirm Holdings could make the financial commitment it's going to take and continue operating. And I'm sure, as Mr. Elcott has indicated, it's their intention that we continue to make those investments. This is a very expedited schedule. We have no interest in purchasing an afterburner and a PTE if it's not going to work. That's something that we're going to know sooner than later. We look forward to seeing you on March 25th and hopefully providing a very positive update on what is being purchased and when. So again, thank you very much.
Thank you. Members of the hearing board on deliberation.
Mr. Chair, I do find I can good cause support the modification. I think it's great that they finally made the business decision to go forward with the new system, at least for the afterburner and the PTE and or maybe the oven. So it's sort of patchwork which they've been doing for the ductwork and so forth. And even though they have replaced probably a lot of the ductwork, and that's maybe why there's a reduction in odors and fugitive emissions. So I think it's a step forward in the right direction in trying to address the issue of non-compliance with both 1128 and potentially 1427. What am I thinking of? Anyway, 1147. Sorry. I did want to bring out the issue, and this is something that on condition 13, I think Ms. Yasmin pointed out, they will adjust the scale of the emission based on the collection efficiency and the destruction on the usage. So it's a sliding scale, sort of, so to speak, on the emissions there. And the other thing I just wanted to point out is it's not AQMD's responsibility. I'm speaking from my experience and as a permitting manager to recommend what equipment that the facility should install. Is up to the facility. The AQMD will see if it'll meet the applicable standards and so forth. So the business decision to go with the PTE and afterburner, the type of afterburner, it's all the rest on the shoulder of the facility, not AQMD per se. But it's their responsibility to make sure that they should that for compliance with the rules and regulations. So with that, I'm saying I have no modifications or anything to the order. It covers everything, and I can find good cause to grant the modification, requested modification.
Thank you. On good cause, any additional deliberation?
Yes, Mr. Chair.
Floor is yours, ma'am.
Thank you. I also can find good cause. I appreciate the fact that they have worked so diligently with the AQMD staff, and I also commend our AQMD staff. This has not been, I don't think, an easy process, and I appreciate the fact that they are wanting to be in compliance and not have any issues regarding odors, and also the still trying to step up and be a good provider to military as well as their other clients. So for those reasons, I also can find good cause.
All right, okay. At this time, I'd like to entertain a motion. In the matter. Oh, I'm sorry, Mr. Pearman. Go right ahead, sir.
So the motion would be that we find good cause in the matter of
yes,
South AQMD versus FlexFirm, facility ID 187620, based upon the stipulated joint proposed findings and decisions, Exhibit 9, as verbally amended today, with respect to the equipment noted, paragraph 4 of that document, G52678 and G75719 being the permits. Among other district rules involved that may be violated were 1128, 402, and 1147. And the facility is at 2300 North Chico Avenue, South El Monte, California. And in that motion that we should include the conditions set forth beginning at page 6 of the stipulated proposed modified findings, and for all the reasons above and as stated here to find good cause to grant the second modified order for abatement.
Is there a second? Seconded by Dr. Abraham. Any further question or discussion on the motion here? None. Dr. Abraham, your vote?
Aye.
Ms. Verdugo Peralta?
Aye.
Mr. Bellica Palan?
Yes.
Mr. Pearman?
Aye.
And Ali votes in the affirmative. The matter is hereby passed unanimously and so ordered. All right, why don't we take a 10-minute break and then we'll come back and we'll tackle Beverly Hills Unified. We're off the record.
Hey, Day.
Yes, sir. Can you hear me?
Yes, I can hear you.
Okay.
And they'll be connecting a laptop, it looks like.
Yeah. They will do a presentation, correct?
Turn your mic on, by the way, just.
Correct. And everything that we have and showing here, I have hard copies of. I just figured it'd be easier to show it, but however you guys want to do it.
You can join Zoom and then you can share your screen if you want to. Just make sure your audio is off, your microphone and your audio.
Okay, Mr. Day, can we get back online and go live?
Yes, sir.
Okay, we're back on the record at 11:01 a.m. The next case before us is Beverly Hills Unified School District case number 6263-1 for a regular variance. Who's representing? Well, let me just ask first, Madam Clerk, did any individuals sign up or raise their hand via Zoom to provide non-evidentiary testimony and/or evidentiary testimony, just general public comment?
No, none in the in person or online.
Okay, perfect. All right, who's representing the petitioner from Beverly Hills Unified?
My name is Steve Bright with Environmental Audit. I'm the consulting firm that's done the majority of the work at the school site. They are not represented by legal counsel today, but I will be speaking on their behalf and providing testimony as well as basically giving the opening statement as to the rationale and the reason why we're before the board for the variance.
Okay, and spell your last name, my friend, for the record.
B-R-I-G-H-T, Bright, Steve.
Perfect, perfect. And who's representing the district?
Nicholas Dwyer, the Senior Deputy District Counsel on behalf of South Coast AQMD.
So am I to assume that we would have individuals providing testimony?
Yes.
Okay. And the district, how many individuals are on your side?
2.
Okay, perfect. And Beverly Hills Unified, how many individuals will be providing testimony on your side?
Up to 6 if necessary.
Okay. Is there any way we can land this plane in an hour before lunch?
I hope so.
Perfect. All right. So why don't we go ahead and administer the oath of office? Excuse me, the oath. All right, let's administer the oath. Pardon me there. All right. Can all the individuals stand? All right, do you solemnly state under penalty of perjury that the evidence that you shall give in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, let the record reflect that all have received the oath, and we will move expeditiously to the opening statements by Beverly Hills Unified et al.
Thank you, Mr. Chairman, fellow board members. My name is Steve Bright. I'm with Environmental Audit, an environmental consulting firm that's been working with the district at the high school for approximately the last 12 years. The school is undergoing a upgrade and renovation program that's being required by the California Department of Education, the Division of the State Architect, and these relate to buildings and necessary code improvements for structural, which is primarily earthquake, mechanical systems, plumbing systems, and electrical systems. In addition to that, in order to meet California Interscholastic Federation requirements for athletic fields, the athletic fields require upgrading and modernization as well. Because of the historical use of the school site for oil exploration and production activities, the California Department of Toxic Substances Control has been the lead agency overseeing investigation work at the site to define the extent of contamination on the property and to direct, if necessary, remedial work to address the contamination. As part of this process, the DTSC has established screening levels for chemicals in various media, and by that I mean soil, gas, and/or groundwater. We have not detected chemicals in groundwater at concentrations above screening levels. We do have chemicals in soil, as well as soil gas above screening levels. And we have detected 3 metals in soil that are regulated under Rule 1466, being arsenic, cadmium, and lead. The estimated volume of soil to be remediated at the site and removed is about 25,000 cubic yards. Because we knew that we had issues with arsenic, lead, and cadmium, and because we believe that it's not possible for us to do the excavation work at night at the school, which is required under the rule, we reached out to the district for some help. The district was gracious enough to send Inspector Michael Haynes out to the site on April 22nd so we could discuss the project with him. He provided us direction on what we needed to do, indicating basically that there was nothing the staff could do. We needed to file a petition in order to try to get the hearing board to grant that petition. So that's what we're here for today, is to attempt to get the hearing board to grant the petition to allow us to actually do excavation work during the day when school and/or joint use facilities are in session. When Inspector Hayes was at the site, we discussed with him the nature of the contamination, and in particular, I brought up one area of the campus which is separately distinct from all contamination detected in other areas of the campus. And that's one sampling location, an area of interest 2A, at sample location A2A 300, where lead was detected at a concentration that was problematic. We did, as we do at all locations where contamination above screening levels is encountered, step out sampling around that location to define the extent of the contamination. And that work was done and indicated that we had a very small area that needed to be removed. Approximately, we were estimating at that time somewhere between 25 and 30 cubic yards of dirt, plus or minus. Testing determined that that waste is a RCRA hazardous waste, a federally regulated waste, where no other contamination on the campus has been found at those levels. So I asked Inspector Hayes specifically whether or not we could excavate that soil, even though we were going to be applying for a Rule 1466 permit to cover the entire campus. His response to us, and it was not only me, it was all of the other individuals, 3 of which are present here today at the meeting, said, as long as you do not trigger the 50 cubic yard limit in 1466, meaning if you excavate 50 cubic yards or more, that triggers compliance with Rule 1466, you are good to go. Great. Based on that, that occurred in April. In May, we submitted, or actually I say we notified the district of our intention for a petition for variance request. And in June 20th, we excavated that lead impacted soil. And even though we weren't required to comply with Rule 1466, as I understand it, because the volume of soil removed was 20 cubic yards, less than the 50 cubic yards that would trigger compliance with the rule, we did monitoring. We did monitoring pursuant to the requirements of the soil management plan that DTSC requested for the site. And what do we mean by monitoring? We did monitoring of dust within the work zone, immediately around where the excavation was occurring. We also used best available control and management practices for dust, meaning we applied water prior to excavating, during unloading operations. We used best management practices for dropping the dirt that was directly loaded into a covered roll-off bin, so there's no more than 6 inches of drop. And that work was completed, done, no problems. We then went and submitted the actual applications for the Rule 1466 permit or the notification and identified some activities that needed to be conducted. And the discussion I just had regarding the lead impacted soil, I'll come back to in a minute, because it turns out that the district had a huge problem with what we did. And to this, right now, I still don't understand why. But notwithstanding that, we also knew that even though we didn't have any soil on the campus that classified as VOC impacted soil, we were concerned, given the nature of the operations, that it would probably be appropriate to get as a precautionary measure a Rule 1166 permit to coincide with the 1466 permit. And that plan has been issued, and we do have that plan. And as part of that plan, and as part of what we had proposed in the variance, is a very extensive air monitoring system associated with doing the work on the campus. We've proposed 7 continuous air monitoring locations, monitor air 24 hours a day. We have one of those locations that has a complete weather station, monitors wind speed, direction, temperature, humidity, all the other things required in compliance with Rule 1466. The other thing I think that's important to recognize too is when you take out that lead impacted soil area and you look at what statistically is left in terms of the contaminant levels. So for example, the screening level for arsenic in soil is 12 micrograms per cubic meter, or excuse me, 12 milligrams per kilogram or parts per million. When you take out the lead impacted data and you run the upper 95% statistical evaluation of that data, and all of this information, I should say, is contained in the submittal that we gave to you guys on October 11th. For arsenic, we have over 673 soil samples that were analyzed for arsenic. Of those, approximately 16.3% had arsenic concentrations above the screening level of 12 micrograms per cubic meter. If you look at the upper 95% UCL calculation, meaning we take all the data of these 677 samples, analyze it, what's the average 95% UCL concentration? It's 9.3 parts per million. So 12 is the screening level. Our average 95% UCL concentration is 9.3. Well, what does that mean? Statistically, it means that 95% of the time when we're excavating soil, we will not have any arsenic concentrations. And that same analysis is also correct for cadmium and lead. We will not have concentrations above the screening level. And the school district recognizes that, you know, the health and safety of the students, faculty, and staff on the campus is the utmost importance. But if you look at the data from this perspective, it kind of tells you that, yeah, the soil's contaminated, but it's not really bad when the UCL concentrations are below the screening level. Versus sites that I've worked on where every location you're excavating is orders of magnitude above the screening levels, and therefore potentially more problematic in terms of impacts to students, faculty, staff. So what we're asking for is basically, let me back up, I missed one other thing. So what we did then too is we evaluated what issues are associated with excavating at night. So the rule states it's not only use of the school, but it's use of any joint use facilities. And the Beverly Hills Unified School District has a joint powers agreement with the city of Beverly Hills to use their campus at numerous times. So the reality of this restriction of saying between 7:30 a.m. and 4:30 p.m., you cannot excavate during the day. When you look at the reality of what's going on for the joint use facilities, which indicate that These facilities are used most nights until 10:30 at night. And on many days, school activities, swim classes start as early as 5 p.m. So we're limiting again now the hours that we could actually conduct the work. Then the other issue, what are the additional costs associated with excavating at night? I can bring the people up here to talk about those, but we've given you those additional excavation costs, and that's also in the back of the October 11th submittal. And when you total those up, and we total those up, not including costs that I generated for our inability to likely be able to find a landfill open at night where we can excavate soil at night, remove it from the site and directly deposit it to a landfill, because all the landfills that are typically used for that type of activity are closed at night. We have in there an email from Chiquita Canyon Landfill saying they will not open at night to allow us to do that. The nighttime cost to excavate soil, and while we can't take it to a local facility, we have to move it out, was about $8 million additional dollars. And then on top of that, we have for construction costs, oversight costs, lighting costs, all kinds of other issues, an estimate from various contractors who are also here that total about $4.3 million. And in talking to the school district staff, they do not have $4.3 million additional dollars to just cover the construction costs of doing this work at night. Forget about the landfill costs of $8 million to move the soil. So in a nutshell, that's why we're here, is to see if we can work with the district to come up with a plan to safely monitor while the school and the joint use facilities are in place so that everybody is comfortable and the school district can move forward with this project. My understanding, and Dr. Brady is the superintendent of the school district and he is here, he has told me that this $4.3 million kills this project. They will have to leave the campus in partly repaired and upgraded manners and will not be able to finish the project. And they don't know when they would be able to get additional bond money to actually complete it.
All right, thank you, sir. Mr. Dwyer, your opening statements.
Members of the board, when the governing board adopted Rule 1466, a key feature of the rule was to prohibit earth movement activities at school between 7:30 a.m. and 4:30 p.m. days when school is in session. And while the governing board was discussing adoption of this rule in 2017, this portion of the rule was strengthened to prohibit earth moving activities at a school joint use agreement property adjacent athletic area or at a site that is adjoining a school joint use agreement property or adjacent athletic area if there is a school sponsored activity or youth organized sports taking place at the site. Why are these our prohibitions for schools and areas where youth sports occur? Why are they in place? The kids and youth are more susceptible to toxic air contaminants. One way for children to be better protected from these activities is for them to not be in the vicinity when this contaminated soil is being moved. Because these activities have the potential to create fugitive dust, this dust with toxic air contaminants can travel to nearby sites to be inhaled. If the children are not there, then they are less likely to inhale the potential fugitive dust. I'm not here to admonish Beverly Hills or high school or its contractor for seeking relief from the very important section of Rule 1466. It is the district's position that performing earth movement activities where soil is contaminated with lead, cadmium, and arsenic adjacent to a school or youth sporting fields while school is in session, while children are playing sports, when there are less intrusive options available here, we must explore those further. Where soil is contaminated above screening levels established by the Department of Toxic Substances Control, an operator must, to the greatest extent possible, avoid exposing children to potentially toxic dust as much as possible. The district's review of the petition and the decision-making into the project identified numerous opportunities where the project could be performed without potentially exposing young minds and lungs to toxic air contaminants. The school district's contractors may follow the required Rule 1466 rules and Rule 403 to minimize fugitive dust and to monitor the fugitive dust. However, there is still a real possibility of fugitive dust that could escape from the area where this earth movement activities are occurring, and the possibility of the activities do not cease. When passing this portion of the rule, the governing board was of the mindset, it's better safe than sorry here. We have considered the points raised by the school district and its consultant and not agree that conditions would be allowed for these earth movement activities to occur while children are in the vicinity. The school district must present evidence for why it's beyond their reasonable control to comply. The school district has the burden of proving to the hearing board that a variance should be granted here. And the South Coast AQMD does not believe the school district will be able to meet its burden. The evidence presented during this hearing will show there is a contaminated site with lead, arsenic, cadmium above DTSC screening levels. Rule 1466 was adopted in 2017. At least since 2022, Beverly Hills Unified School District has known they need to comply with 1466 school hours limitations. In June 2022, the school district's consultant sought an exemption. No exemption was granted. In October of 2023, the school district and city entered into a new joint powers agreement. In April 2024, the school district's consultants reached out about an exemption. DTSC has not informed South Coast AQMD that the school district could be exempt from the school hour limitation. No exemption has been granted. The school district filed this variance. The school district provided additional information related to the feasibility of compliance. The elephant in the room suggests the project may cost more and take longer. None of the materials or discussions to date have convinced the district that the compliance is beyond the school district's reasonable control or that emissions will be mitigated to the maximum extent possible here. The evidence shows a facility pre-committing to accomplish a goal without taking into consideration compliance with an applicable rule, and then attempting to get relief from that rule to fit the project back in with the pre-commitments. We recognize complying with the rule may make the project take longer and be more expensive, but that balanced against the potential harm to children's brains and organs is not enough to tilt equities in favor of granting a variance here. Unless we have a bubble or a permanent total enclosure over the earth movement activities here, there's nothing the school district could do that would address this concern about children being present. Additional monitoring is not sufficient. It is undisputed that toxic materials exist in the served. That's all I have. Thank you.
Thank you. So my good friends over at Beverly Hills, would you like to call your first witness? And just to be very clear, if any individuals are tuning in, the specific school area we're referencing.
I'm not sure I understand that last part. What do you mean a specific school area?
Yeah,
Like
right.
where-
So, yes. Is there some, do you have a map or diagram showing the actual area, or is this just specifically the high school?
There are areas on the high school. Can we put up the one that says, hang on one second.
There is a map attached to the petition too, I think.
Okay, is there any way to put that map up? I don't.
It's in Exhibit C.
Yes, okay, now, I saw the map, but what I'd like for you to put the map up so any individuals viewing can also see that portion. Because I do believe you have access to the screen to put up a diagram or a map, correct? Okay. All right, so please call your first witness, Mr. Bright.
Good.
Turn your microphone on, my friend.
Good morning. I'm not sure.
Yeah, we can hardly hear you.
It's not giving me that. There we go.
There we go. All right.
Good morning. My name is Dr. Michael Breggy, and I'm the superintendent for the Beverly Hills Unified School District. I just want to thank you for giving us this opportunity to give you another perspective on this matter that we're talking about today. This is a very difficult matter that we are navigating.
Objection, he's testifying.
Yes, Mr. Dwyer, just for clarity, he will be testifying. And were you sworn in, Mr. Superintendent?
Yes.
Okay, so I assume, Mr. Bright, you would question him? Or you guys would have a strategy as to how we're going to extract the information from him?
Okay, yes, we can question him on the activities. What we did, and I apologize because we are not lawyers, is we included in the information letter provided by Dr. Breggy regarding the impacts associated with this project not moving forward. So that's included in Exhibit G. And if we can share this screen, which apparently we cannot share our screen.
Okay. And Madam Clerk, while they're doing that, can we go ahead and mark the exhibits just so that we're all on one accord?
Okay.
Can you read them off into the record, Madam Clerk?
Now I have 3 letters
Okay.
submitted. Is that?
Yes, ma'am.
The October 11th letter signed by, sorry, let me go through this. Okay, from Steve Bright, dated October 11. So that will be Exhibit 1. And then we have a letter from Simon Pollard of, is it Swinerton? Be Exhibit 2. And then Exhibit 3 is a letter from Elliot Meyer of Fonder Solari.
Perfect. Thank you, Madam Clerk. So, Mr. Bright, so you do have access to place your presentation within the Zoom chat, or excuse me, the Zoom feature, as well as the overhead. But if you would just kind of walk the superintendent through a series of questions, and then what's going to happen is the district side, who is the respondent, would have an opportunity to cross-examine. And then you can then direct, and then the hearing board will then ask a series of questions if so desired. But I'm going to tell you now, my friend, you have to walk everybody through this, and we may be going beyond noon because this is a very complicated matter, and the district appears vociferously opposed. There's no findings at all. So you're going to have to make a strong case today, my friend, just to be very candid with you. So the floor is yours, Mr. Bright.
Okay. Based on that, I think what I would like to do is move to discussing other witnesses first, if that's appropriate. And we would call to testify now, Mr. Elliot Meyer from Fonder Solari.
Okay. Mr. Meyer, just spell your name for the record, my friend.
Elliott. Last name is Meyer, Meier.
All right, Mr. Bright, your witness.
Yes, I'm sorry. Mr. Meyer, could you explain your relationship to this project and your duties?
I am the project manager for the construction management company, Fonder Solari.
We requested you to take a look at what additional costs would be associated with moving the project from daylight hours to nighttime. Can you indicate to us what those costs are and what you estimated the cost to be?
Yes, so we looked at what it would cost to excluding the one of the projects right now for the balance of the site, which was this cost is associated with the work that would be in AOI 7, AOI 2, and 2A. We have found that in order to just construction costs alone to work at night in the restricted hours when there is no further student or joint use facilities, we're looking at an increased cost of roughly $2.8 million.
Okay. Did you look at,
Chair, I'd just like to point out that we have not received physical copies of these documents today, so we request that we have those available so that we can follow along with petitioner?
So, Mr. Wright, the documents for which you reference, are those documents included as your exhibits, or are these documents supplemental materials for which no one has seen?
No, they were included as exhibits as your clerk told you. So you have them, and I would assume that Mr. Dryer has them, but if he's not, I can hand them to him right now.
Okay, perhaps we would give the respondents a copy of those documents if you have them within your possession. And then we'll proceed. So just so we're clear, Mr. Bright, we're talking about general obligation bond dollars, just for the record. We're not talking about general fund, right?
That's a question for Dr. Brady.
Okay, very well. Go right ahead, Mr. Bright. Continue with the questioning of your witness.
Well, I think I'll defer the questioning now to Mr. Dryer. We've indicated our focus was twofold. One, we understand their concern regarding the levels of arsenic, lead, and cadmium. That's the reason we did the statistical analysis, to demonstrate when you look at the data collectively as a whole, 95% of the data is below the screening level, meaning we would not even be here talking to you and requesting a variance had those numbers been what was shown on the data, the raw data without evaluation.
Mr. Dryer?
Yes.
Mr. Dwyer?
Mr. Mayor, is my speaker on? Yes. This one-page letter that you submitted October 15th, do you have any supporting information or documentation for these figures that you've come up with?
What do you mean by supporting figures or backup?
So you have a total here. You have 28 million or $2,803,767 additional costs to be incurred. What is that number based on? Where's the supporting data that supports that total?
Certainly. So that is based on extrapolated data from projects that we have, current and past. And because we don't have any subcontractors or contractors involved with this, we used our estimating background and data to develop this number. We came up with a quantity of soil that had to be moved. We developed a unit cost of dollars per cubic yard of dirt that had to be moved. And then we also looked at the overall general conditions, added general conditions that would be added into a project of having to work at night, as also the extended duration of having shorter work hours.
I think I object to that this line of this inquiry into these figures without having any of that supporting information before us. There's no real evidence before us that supports this figure.
And I would have to sustain Mr. Dwyer's objection. And to be very honest, we do have very limited information before us. And I'm just kind of finding it hard to follow. I know a little bit about this, because of my involvement within the K-12 space, but there's not much information to hang our hat on this morning.
I still have some additional questions for Mr. Meyer
Go
there.
right ahead.
What is the budget for these earth movement activities at Beverly Hills High School?
The original budget? What budget are you referring to?
The budget just for conducting the earth movement activities at the high school. If you have multiple budgets, you can answer to that as well.
We have an overall cumulative project budgets. We don't have it broken down by earthwork. So I'm not sure what you're actually asking for.
That answers the question. So you do not have an actual budget for the earth movement activities? Is that correct?
So we can have our general contractor that is currently working on the campus. He can provide some more information about specific budget numbers that for active projects. So that may be better directed to him.
Okay.
That line of question may be better directed to him.
Well, I'm just trying to get to how is there a 28 million or $2,800,000 addition to perform earthwork activities after hours here? Addition to what?
So I can answer that. So we have additional lighting that needs to be for working at night. You have added traffic control because we now have a separate crew that is working at night apart from general construction. So you're adding an additional work crew to cover that work. You also are going to have additional general conditions, meaning you're going to have a whole separate supervision crew that's got to be on site for the night work only. That's being done in conjunction and above what's happening during the day. Yeah, and exactly. And then we're going to still have additional overtime and work for the crew to be working at a swing shift type rate.
Do you have that broken down anywhere for?
It can be provided. Okay. Yes.
Do you currently have bids out for earth movement activities here?
Yes, that is where Swinnerton Construction would come into play.
Did the requests for bids require compliance with applicable laws?
Yes.
So wouldn't those bids have considered compliance with 1466 E15?
No, because we were planning to have a variance to do that work.
So the plan was to seek a variance so you didn't have to comply with 1466 E15. Okay. No further questions.
Mr. Wright, did you want to redirect before we move to the board's opportunity to provide questions?
No. So I think we'll move now to the Swinnerton.
Oh, hold on.
No,
Actually, no, we're going to have members of the board ask questions if they so desire. And so why don't we, I'm very confident there are some questions, but let me kick it off. And I normally wait to the end, but I'm just kind of curious. So initially when you bid the work with the notion that you would seek a variance. You didn't bake the potential $3 million in?
So to answer bluntly, no, that was not baked in because of trying to work through this. We have been out to bid before we came to this board. If that makes sense.
Okay, and so let me also ask you, so we're using general obligation bond money, correct? Or general fund money?
And
Can we bring up Amin Solari, who is with Fonder Solari, and he can answer your questions on bond sources of the money, because Mr. Meyer nor myself are knowledgeable on that issue.
Okay, so
Finish with Mr. Meyer first.
yeah, exactly. Yeah, we'll finish with Mr. Meyer, and then we can always come back to that. But I am very curious, and Mr. Dwyer brings up a very good point as far as bidding the work in alignment with applicable laws and provisions, whether it be state or regional. And I'm struggling with the notion that you would bid the work to seek a variance for which you may not receive. And then if you don't receive the variance, now you have to go and perform a change order, I would assume, which may increase that cost from 2 million to 4 million or 6 million, who knows, right? But there's really no analysis provided to the hearing board today. And so, okay, one last point. When we just began the work, was there any environmental analysis done, and who was the environmental company providing the analysis? Soil sampling, et cetera.
That would be us, Environmental Audit Inc. And I'm not sure I understand what you mean by analysis, but there's extensive analysis of all the data related to the sampling and testing at the school site pursuant to the requirements of DTSC.
Correct, but so we knew, phenomenal answer. So we knew early on that there would be contaminants that would require remediation or removal.
Yes, but you don't know what the full extent of that is until the project sampling and testing is completed. Once the project sampling and testing is completed, then we identified 3 metals which exceeded the screening levels that would trigger 1466. And I think part of the issue, and Mr. Solari can talk about it better, it's not as though the school district can just go back and ask for more money. They had bonds issued already in specified amounts, which we now trying to complete this project. The school district, again, others can verify what I'm saying, has spent almost $100 million on abandoning the former Venico site that's at the school site. So there's $100 million gone that they wanted to use toward modernization of the buildings and the fields that they couldn't use for that purpose because Venico filed for bankruptcy. The school district and the city of Beverly Hills became responsible for that site. And my recollection of the total number was about 120 million, of which the school district was responsible for approximately $100 million. No one could take that into account that was going to happen.
No, and I understand that, but I guess what's been provided as testimony this morning is you bid it with the assumption of seeking a variance. And so to be very candid, that is very presumptuous to believe that you would receive this variance absent any additional information that would substantiate or validate this. I guess if I didn't have a measure of understanding as far as how school construction works, then perhaps I wouldn't understand. I'm dealing with this in another role, and so I just couldn't. Has the school board been apprised of this? Are they aware?
yes, the school district is aware of the current situation.
Yeah, your microphone is off.
I apologize because the light isn't coming up. The school board is absolutely aware of this matter and where we are today.
And they're aware as to how it was bid, with the assumption that a variance would be sought and the district would save $2 or $3 million?
I think there needs to be more clarification about that statement and about how the project was bid.
Okay, I rest. Any additional questions from members of the board?
Yes, Mr.
Ms.
Chair.
Peralta.
Thank you. So what you're telling us is on this 2 million, you do not have an itemized list Then where is that and why didn't you provide that?
We can provide that.
Okay, that should have been provided this morning. So yes, we need that ASAP. That's number one. Number two, in reference to your environmental study, if that's what you want to call it, was there any consideration taken to any medical reports that have come out of academia or from any of the large medical associations which we have on record? Was there any consideration? Because within those reports, there is information that is in regards to how children are much more susceptible to contaminants, and especially female children are much more susceptible. And I don't see anything here that has been mentioned, even mentioned, in regards to consideration for that. I understand that this is about dollars and cents as well. However, if we're talking about moving to a time when the children are not there, I would think that that would be a high priority. And the fact that you're even willing to look at moving whatever, the material, while children are there, to me is unconscionable. Also, I will agree with the chair, the assumption that was testified to earlier by Mr. Meyer, I believe. He made the comment that it was with the thought that a variance would be included. That is quite an assumption, because this board still has to vet everything that you are bringing before us. And I see a lot of data, but I don't see the relevant data, especially something like the itemized list of monies that you're going to spend, as well as consideration for the population that is there, and you're willing to put them in harm's way. That's all I had, Mr. Chair.
Can I
Thank you.
respond to any of those or no? Sorry. Okay. So with respect to looking at studies and the impact on children, the screening levels that were developed for this site were done by the California Environmental Protection Agency, Office of Environmental Health Hazard Assessment, known as OHIA. The standards and the screening levels that we're using on this site, the school site, are for unrestricted land use. That's the most stringent standard they have. That's basically residential development. So all of the screening levels that you see in the documents are based on that standard. With respect to looking at other studies and evaluating, no. But DTSC did that, and that's why they told us we need to use the unrestricted residential screening levels.
Okay, I can accept that, and I'm aware of those agencies. However, I think when you're looking at the fact that you are going to be conducting these activities while children are there, I would think that you would try to go beyond any type of standard, let's say, because of the fact that they are children and they are much more susceptible than the regular population. Thank you, Mr. Chair.
Thank you. Any additional comments?
Yes, Mr. Chair.
Mr. Balakapalan.
Mr. Meyer. Mr. Meyer, how long have you been the project manager for this site?
I have been out since July of 2022.
2022. Were you aware of the rule prior to you taking the role of project manager, Rule 1466?
No, not before 2022.
Subsequent to 2022, then you were aware of the rule?
It was brought to our attention after that, once we got started, yes.
And you were aware of the restriction on the hours of activity during school hours?
It was discussed.
Okay. So, and in spite of that, there was a joint agreement, that joint powers agreement. Were you involved in that with the school district?
No, I was not.
Okay. All right. Thank you. I have no further question.
Mr. Pearman.
Yeah.
So you're reaching for your microphone?
Couple of questions. In Exhibit 3, which you signed, you say there's an additional $2,803,000 to do the earthwork after hours. And Exhibit 2, which is from Swinnerton, has a list of $1,568,000 for night work. So help me explain the gap or difference between the Swinnerton number and the number you put in your Exhibit 3.
Those are for excuse me, two different projects. So we have two different projects that we're forecasting for this campus.
So you're saying that following the rule would cost you over $4 million total?
Correct.
That's the position. All right. And do you know what the retaining wall south soil nails is at 799,000 in the Swinnerton bid, or do I have to speak to Mr. Pollard about that?
It'd probably be better to speak to him on that one.
And in the statement opening by the district, they mentioned that they felt there were less intrusive options that you could undertake in lieu of the variance you seek. Did you consider any less intrusive options beside what you mentioned in your petition in the letter of October 11th?
I will defer to others to answer that question.
All right, no further questions. Thank you.
Any additional questions? All right, Mr. Bright. So there's a couple ways I believe we can handle this. The district is opposed. There appears to be some confusion from members of the hearing board. We can proceed with a vote, or we can look at continuing this to a different date.
We would appreciate the opportunity for a continuance to provide some additional information that's been requested today.
And so perhaps we would consider a pre-hearing conference. Of course, a subsequent date.
Yep.
And then we can try to work through some of the nuances, but it would really be helpful, Mr. Dwyer, my very good friend, if we could find a palatable solution so that the members of the board are at least provided with some proposed findings. Now, if there are none, I understand. But if we can try to find a pathway to assist Beverly Hills Unified, I believe it would serve in everyone's interest. So perhaps we can get with the clerk, and the clerk can provide, of course, subsequently, the clerk can provide some dates for which we can reconvene, giving ample time to be able to gather additional research as well as analysis that members of the hearing board might desire. Is that fair, Mr. Dwyer, as well as Mr. Bright?
It's fair, but I can tell you, Chair, it's unlikely that we'll come back with any proposed conditions here. It's kind of an on and off switch here. You either don't have children present or you do. So there's not much that we would be willing to agree to for a variance here.
All right, so Mr. Bright, you've heard from members of the hearing board, and perhaps you may want to come back and provide at least some substantive information to ensure that there's a measure of understanding, and then we would just simply proceed forward accordingly. So how much time would you think you need? A few weeks?
Mr. Chair, I was going to object to that. I think we have the information we need, I believe, maybe further testimony to make a decision on this matter without extending it.
Members of the hearing board, what are your thoughts? Continuance, or should we proceed forward?
I'm fine with the continuance.
Okay, Dr. Abraham?
Continuance.
Ms. Verdugo-Peralta?
Only because I think we need that information to make a better decision.
Okay, thank you very kindly. All right, so members from the Beverly Hills delegation, how much time would you need?
2 weeks is fine.
Okay, so are you comfortable with me working in concert with the clerk's office to provide a few dates for which you can consider?
Yes.
And then working, of course, with Mr. Dwyer's schedule as well.
Yes.
Okay. Madam Clerk, so can we just continue this with some additional dates provided subsequently?
We can, but I think we do need to, in order to preserve the notice, we need to
Okay. Okay. Okay, so then why don't we set, so if we're, can we set the 19th?
Can I ask a question?
Yes, sir.
Chair? Is the continuance is to get cost data. Is cost data going to be the criteria to make a decision here, or the rule, which is black and white, basically, on the prohibition?
Well, I believe each member has concerns and they've expressed those concerns. And so I believe it's on the burden is on the district to be able to provide a measure of understanding. I would hate for the district to proceed, meaning Beverly Hills Unified to proceed absent answers to the questions as posited and the outcome is not favorable.
So I see the 19th is Hyperion though, right?
Yes, we have 2 cases that day, so that would not work. And the 20th as well, we have 3 cases.
Okay, okay. All right, so okay. So then, and then we have that let's see.
Probably
So we look at December
first
3rd?
weekend, right?
Can we look at December 3rd?
Is the 5th okay? 3rd is with that,
I'm unavailable on the 5th.
okay,
I could be there
the 3rd,
the day
Yeah.
before.
So can we do the 3rd or the 4th?
okay. On the 4th, we do have another case, but I don't think that one shouldn't go very long.
No problem, no problem.
We want to add it there.
Yes, ma'am. Yes, we'll add it to December 4th.
There's already a case on the 4th, you said?
Yes, there's one.
It's one, but it probably should go fairly quickly. Okay, so December 4th?
All
Should
right.
there be a motion first for continuing on? There should be a motion for the continuing the hearing.
Historically, have we proffered a motion to continue?
Looking at the rule, hearing board may continue a hearing on its
Okay,
own.
not a problem. Chair, entertain a motion to continue the hearing until December 4th.
So motioned.
It's been moved by Ali, second by Dr. Abraham. Any further question or discussion on that motion? Hearing none, Ms. Verdugo Peralta.
Aye.
Dr. Abraham.
Aye.
Mr. Balakapalan.
No.
Mr. Pearman.
Aye.
Ali votes in the affirmative, 4-1 on the continuance. See you December 4th. This hearing is now continued at 11:48 a.m. and we're off the record. Have a phenomenal morning.
Thank you.
Mr. Chair, I just wanted to make a personal note, not in regards to this at all, not this
Ma'am.
matter anyway. Just wanted to wish my husband, who's sitting in the audience, a happy 48th anniversary.
Happy 48th anniversary. All right, folks. You guys have a phenomenal